Welcome to Creamer Media's Polity. I'm Amy Witherden. With me in the studio I have Priya Chetty of Chetty Law to discuss copyright law and her firm's involvement in the African Copyright and Access to Knowledge project. Welcome, Priya.
Thank you, Amy.
Please explain how copyright law works.
Well, copyright is one of a group of intellectual property rights. So people are probably familiar with the terms trademark and patent, and copyright falls within that category of intellectual property rights. So it grants the author of a specific category of works limited rights of exploitation and use of the work, and that person has to be the creator or the author of the work. So what's different about copyright to some of the other traditional intellectual property rights is that it subsists automatically. So from the time somebody scribbles on a piece of paper or starts writing the first chapter of a book, they immediately have copyright on it.
No registration process?
No registration is necessary. While people have the option of registration, so for instance, depending on the category of work, so it applies to literary works, musical works, sound recordings, those kinds of works. But should a person, for instance, decide that they want to register the copyright in a film, they are at liberty to do that, but it's not actually required.
What are the objectives of copyright law?
Well, it depends on the legislation of that country. So copyright, as with other intellectual property rights, is what we call as lawyers jurisdiction dependent. So it depends on the statute or the legal system of that country. And in South Africa, it's governed by the Copyright Act 98 of 1978. And in the Act, it says that an author or creator of a work gets specific rights, such as the right to reproduce the work or to copy the work or to distribute copies of the work. And also to grant that right to other people. So for instance, if somebody gets a license to read a book or to use a piece of software, what they're actually getting is rights granted by the creator of the work to actually use that work. So in terms of the objectives of the legislation, in early times it was considered a social contract, so that a creator of a work would be incentivized to create something so that they could commercially exploit it for a limited period of time. And after that time expires, it would fall into what we call the public domain. And that means that the public at large can benefit from use of that work. However, in recent times, it's swayed from that initial intention, but that was really the intention behind it. It's what we call the social contract. Yeah.
Why is copyright law important?
It's important, the people always use the word incentive when it comes to intellectual property. And so for many years now, we felt that in order for someone to create something, we have to give them an incentive to do it. But, as I said, in more recent times, what we're finding is that people are actually creating for the sheer joy of creating. And projects such as open source projects and Creative Commons show that people don't necessarily need financial incentive to create. Someone who wants to practice their craft. So, a scientist will still create some amazing scientific discovery, even for the sheer joy of producing the discovery. And someone will still write a poem or a book, even though they don't really expect to get any financial reward. So times are changing, and intellectual property, the way we originally intended it, is also changing and swaying from its original intention.
How does copyright law relate to access to knowledge and learning materials, particularly in Africa?
Africa, as with other developing countries, face a number of issues, and high on that priority list is education, and very close to education as a goal is access to learning materials or access to knowledge materials. And in order for countries to improve education, developing countries to improve education, they will have to improve access to textbooks and basic learning materials that people need in order to fulfill the requirement of education. So particularly in Africa, as with other developing countries, the rate at which we can provide access to learning materials, or the ease with which we can provide access to learning materials, is quite an important factor to see how we're going to do in the long term in terms of sustainable development and improving education and improving knowledge workers and participating in a knowledge economy.
So copyright law could impede that access, in other words?
Well, copyright law is, in evaluating access to knowledge, there are a number of factors that one could look at. And the more obvious one is copyright law, because, the rate and ease with which we distribute materials is so closely related to what people can do under copyright law. So to put it into basic terms, if a textbook is published, the ease with which you could distribute 500 copies of that is really dictated by copyright law. And so important questions need to be asked about whether copyright law promotes access to learning materials or, defeats some of the objectives we have in terms of education and inhibits access to learning materials. So the link is so obvious and so close that it's a great starting point to say if we're going to improve education and improve access to learning materials, we have to ask whether copyright is helping us or inhibiting us. Yeah.
What are the aims of the African Copyright and Access to Knowledge project?
Well, it's a very interesting project, and there are a number of interesting things about it. One of the things that it aims to achieve is to create a network of researchers around Africa, and it certainly has done that. A few years ago I didn't have any friends in Kenya or Mozambique, and now I do after working with them for 2 years. So one of the project intentions from the IDRC's perspective and Shuttleworth Foundation perspective, response to the project, is to create that network of people who can speak freely about access to knowledge in Africa. And then what it does on a more real basis is test copyright law in the study countries. And there are 8 study countries. And it tests it to identify whether copyright law within the study country actually promotes access to knowledge or inhibits it, and to what extent copyright law can be improved or remedied to improve access to knowledge. So if we find that the answer to the first question is that it impedes access to knowledge, then what recommendations can we provide to remedy those, I wouldn't want to say defects, but those problem areas.
Which countries are involved?
I'm going to try and remember all 8. It's South Africa, Kenya, Senegal, Mozambique, Morocco, Uganda, Ghana, and Egypt. Yeah.
What are the primary recommendations coming out of the AC A2K South Africa research report?
Well, there are a number of outcomes, and the outcomes are quite varied because of the research methodology. So, for instance, we didn't just look at the legislation and then report just on the legislation. We had interviews with stakeholders from government and publishers, so rights holders, and then users, so people at tertiary institutions that rely on access to learning materials. And along the way, we've had a number of recommendations. If we look just at the legislation, there are a few stark recommendations, and it's very similar to recommendations coming out of India and other countries that have gone through this process before, where they've asked similar questions. And a key example, for instance, is that the Copyright Act doesn't speak to the needs of sensory disabled people, and they should have as much right to education, as enshrined in the Constitution, as people who aren't sensory disabled. And the Act doesn't allow for conversion or translation or adaptation of works for their use, and it's a right that they have for learning purposes, without the consent of the person who created the work. And so that's one of the things that can be remedied, so that a librarian can, translate something into Braille and make it accessible to a sensory disabled person. Then the other ones are limitations and exceptions. So when a learner wants to use a study pack or a textbook, they are looking for some kind of clarification in the legislation that says, for learning purposes, I'm able to use this book. Or a library will look for clarification that it can actually distribute this copy of a book via distance education to someone. And when we look at the limitations and exceptions under the Copyright Act, they're so vague that it actually deters people from exercising rights that they have. So it says, for instance, you can use a percentage of the book, and people thumbsuck what the percentage of a book is. And so what we need are clarifications on that, so that people feel, more liberated to actually use it. And then, more recently, we've had a number of very interesting developments, and as an IT lawyer, we feel quite proud about the fact that we have a free and open source software policy. And that's all in aiding access to ICTs, so making software and computers more accessible to people. But what we find is that, if you're going to have ICTs, you're going to need content for it. And if you're going to use ICTs for education purposes, you'll need to have learning materials available on those ICTs. And so what is not found in corresponding legislation such as the Copyright Act is the ability to take learning materials and put them on the ICTs. So what we want is an alignment of, in the same way that the country is dealing with promoting access to ICTs, it needs to promote access to learning materials as well, so that we can place content onto those ICTs. There's things like that. And then there are more practical examples. So orphan works, for instance. It's an issue that's been dealt with in other countries. So sometimes a user, even a journalist who wants to cite a particular reference piece, will look for the author of that piece, and that author is unlocatable, unidentifiable. And your interest in that piece is quite legitimate. You just want to cite it, and it's a good reference point. And what other countries have implemented and what we are looking for is some way in which people can use those so-called orphan works under reasonable terms. So the state must create a system that says, if you have tried to find this person and you can't, you can apply for permission and you can use it. We don't want to limit the amount of knowledge work that is available for use. We want to expand it. And so if somebody really wants to use a great piece of work and it is an orphan work, there must be a method to use it. And then, we also make recommendations that say we must encourage debates about access to knowledge, not just in copyright, but in, on other aspects or tests to see whether access to knowledge is happening in South Africa. So we promote those debates, yeah.
So there's quite a bit of room for development.
Absolutely, yeah. I think as a result of this, there's been quite a few people who have expressed interest in the project. And what we're expecting is that some of the recommendations will be followed through. It won't necessarily be the research team, which comprises of Tobias Schoenwetter, Caroline Gube, and myself, that will implement the recommendations. But we're hoping that government will pick up on it, and when they're reforming the Copyright Act, take some of the recommendations and implement them. They can look at model law in Australia or some implementation in the United States and look for some positive aspects there and try and introduce it into our new Copyright Act. The Copyright Act is outdated. It doesn't deal with the digital world. That's how it stands at the moment. It doesn't provide the answers that we're looking for. And what we need to see is that a reform process gets some wings, and that they look for sources of information to say, how do we improve it, and how do we, if we are going to promote our introduction into the global economy and participation, what do we need from intellectual property rights to sustain that participation?
Is reform of the copyright law on the cards?
We hope so. I mean, it's speculation at this time. There have been some rumors and some hints at a meeting that's going to be put together. We only hope, and we will bang doors to be a part of that process. And just make sure that the voices are heard from the other side in terms of access to knowledge and promoting the right to education.
Great. Thanks, Priya. That was Priya Chetty discussing copyright law and current initiatives to improve the body of law and enable greater access to information in Africa.